to help you not be that lost in these general questions, so more specific ones. Thank you.
Thank you. So I will address the second to last topic, and that is Professor Jones's question whether the award must state reasons for a tribunal's choice of one expert over the other expert. So in our submission, as we've shown yesterday and in TECO's pleadings, those reasons are included in the award. So in our case, we do not have that situation. I would point out that there is no ad hoc committee decision that annulled an award on damages for a failure to indicate reasons for the choice of one expert or another expert. Nevertheless, I think one authority the committee might find relevant is Antin v. Spain, and we will put that on the screen. It's slide 25 of TECO's closing. And in that case, this was a case that related to solar photovoltaic power plants. Claimants, experts assumed that the lifetime of those projects would be 35 to 40 years. The tribunal and calculated damages on that basis. The tribunal did not accept that and concluded that the lifetime of these power plants was 25 years instead of 35 to 40. And on that basis, the tribunal made an adjustment to damages. The damages included lost future cash flows claimed at 148 million euros, and the tribunal reduced that by 36 million euros, so a big adjustment downwards. And Spain pursued annulment of the award on the ground that the tribunal failed to explain how it arrived at that deduction of 36 million. And there was a rectification proceeding later on, and as part of that proceeding, the tribunal explained that the reason why it made that adjustment, why it reduced the cash flows by 36 million was, quote, the tribunal's own calculation of the lifetime based on the evidence in the record and the reports of the experts, unquote. So this was the only explanation that the Antin tribunal gave for that decision on damages. And again, Spain argued that this was annullable, including because it was a denial of the right to be heard. The application was dismissed by the ad hoc committee, which noted in its decision, in fact, that there were no further explanations in the award about how the said evidence and reports support this figure. So it acknowledged that all that the tribunal said in connection with that was that one sentence. Nevertheless, it decided not to annul. It stated that, quote, estimates of damages are by their nature approximations that the tribunal makes based on its view of the underlying facts and evidence. These are exercises of discretion and judgment that do not lend themselves well to detailed explanations or precise calculations. And in view of this, the committee finds that the tribunal had not failed its duty to provide reasons for its assessment of damages, unquote. One last topic I want to cover briefly. That's Guatemala's argument that there was a serious departure from a fundamental rule of procedure. Again, the rule of procedure needs to be identified. Otherwise, it fails at that threshold. The application fails at that threshold. The Wiener Hotels v. Egypt and the Duke v. Peru committees stated that and dismissed annulment applications in circumstances where the applicant had failed to identify the rule that it was referring to. Today, Guatemala suggested that TECO itself previously suggested that the right to be heard is a fundamental rule of procedure. That's correct as a general matter, but Guatemala here didn't make its case on that point. And that concludes my presentation. Thank you.
Thank you.
So thank you. So I'll just make a few comments on the interest rate. So if we begin with slide 30, this is the slide we had during our opening. I don't believe I talked through it. So just very briefly, so we're all clear on precisely what we're talking about, the interest on which amounts. You'll see here our claim, as you know, was for 21 million up until the date of the sale of EGSA, and another 225 million after that date. The original tribunal awarded us the full amount up to the date of 21.1 million, and it awarded us interest on that amount from the sale going forward. And that interest was awarded at the U.S. prime rate plus 2%. It denied us interest from the date of the breach up to the date of the sale. And it said it would be unjust enrichment to give you interest on the amount of damages from the date of the breach. That was annulled for failure to state reasons. Also, what was annulled was to deny or reject our claim for all damages after the sale from 2010 forward. The annulment committee upheld the award of historical damages of 21.1% and post-sale interest on those damages at the U.S. prime rate plus 2%. Those were challenged by Guatemala in its annulment application, but those were upheld. So the resubmission tribunal, when it came to damages, as you know, it awarded us the 26.8 million damages, which is the loss of value damages up until 2013, the end of the tariff period. It awarded us interest on those new damages at the U.S. prime rate plus 2%. It also awarded us interest on the historical damages from the date of the breach forward. The parties agreed on that amount of interest. That was $838,784. So they agreed at that. And they agreed that the way that should be calculated is by using EGSA's WACC. So that number was agreed. So then you have that interest that takes you up to 2010 on those historical losses, right? And on that piece of interest, you need to bring that forward. You already have the historical damages, and the interest on those is going forward at U.S. prime rate plus 2%. And the resubmission tribunal held that on these pre-sale interest award, that also is carried forward at the U.S. prime rate plus 2%. And it's those two amounts, or the interest rate on those two amounts, that Guatemala is now challenging. So now Guatemala doesn't seem to dispute the fact that during the resubmission tribunal proceedings, that they never argued that the resubmission tribunal was bound to apply interest on those amounts at a risk-free rate, or that there was any res judicata effect to any language in the original award stating that they have to apply it at a risk-free rate. So they not only did not argue that, they expressly argued, as I showed in opening and at slide 31, you can see it. They expressly said the tribunal, the resubmission tribunal, is free to set the interest rate on these two amounts. Now, this morning, for the first time, they say, well, it doesn't matter what we said. It does matter what they said, because they are stopped now from arguing that this decision, these rulings should be annulled because the resubmission tribunal was bound to apply a rate when they expressly argue to the resubmission tribunal that they were not bound to apply any particular rate and were free to determine the appropriate rate. They say it doesn't matter. They haven't waived any right. They're not estopped because the resubmission tribunal manifestly exceeded its power because they were bound to apply a risk-free rate by virtue of res judicata. And even if they argued the opposite to the tribunal, it would be beyond their jurisdiction to ignore this res judicata, if I understand this argument. And that's just false. There's just no merit to that argument. Among many other problems with the argument, first, as we said, they are stopped from arguing this. But it doesn't make any sense because the paragraph that they rely on in the award, that language we've shown you, paragraph 766, where it says they should apply a risk-free rate, paragraph 767 says they should compensate TECO at a rate that it allows it to borrow a commercial rate at US prime rate plus 2%. As I just showed on that first slide, there was never any award of interest at a risk-free rate. So how can a non-ruling be res judicata and binding on a subsequent tribunal? The only award of interest that was ever made by any tribunal prior to the resubmission tribunal was at the US prime rate plus 2%. That's the only award of interest. And then we saw the US court enforce the award at that rate. Guatemala paid that rate. If anything's going to be res judicata, it's going to be what was actually ruled upon. It would be that ruling. They're asking you to ignore what was actually ruled upon and to grant res judicata effect to some language in the award that wasn't even a ruling. And it couldn't even be a ruling. It doesn't even set forth a rate. In opening, Guatemala said something when asked about a risk-free rate, and they were asked treasury bills, and they said something like, oh yeah, it could be 10-year, it could be 5-year. Well, those will be different rates. How do you enforce that? It's not giving you a rate, it's just giving you a concept. It's just language there. It's not a ruling. It's certainly not a definitive ruling that could have any res judicata effect. And as then the tribunal itself said, when rejecting an argument that there was any res judicata effect with respect to interest, those two paragraphs are internally inconsistent and therefore they can't be granted res judicata effect. Guatemala also talked today about paragraph 768. And if we could just very briefly put that on the screen so you can see the wording. That was one of the paragraphs that was expressly annulled. And Guatemala said this morning that that was annulled. And the premise for paragraph 768 was 767. So therefore 767 should be annulled. And paragraph 766 is the only one that stands. Apart from all of the other reasons that I've just explained why 766 could not possibly have any res judicata effect, they're also misreading the award because paragraph 767 was not predicated on 768. 767 was not annulled, and that was the rate that was actually applied. I don't know if we can bring up the paragraphs in the award 768 just so we could easily look at it. If it takes a minute, don't worry. Let me just say that.
Meanwhile, sorry,
Yes.
just a very, very quick question. Was in the relief sought by TECO in the resubmission proceedings, was there a claim for is that the post-sale interests?
Yes.
Yes, there was a specific relief, correct?
Yes.
And at no time did Guatemala raise an issue regarding lack of jurisdiction for any reason, res judicata,
That's
or
correct.
res judicata not being waivable, nothing at all.
That's correct.
Thank you.
So as not to keep us here longer, let me just say that paragraph 768, when it's annulled, that's the paragraph that says that it's awarding that it's not awarding, that it's awarding interest on the historical damages at prime rate plus 2% from October 21st, 2010 until full payment. So it was only awarding interest from the date of the sale forward. That's why that was annulled, because the rejection of the interest pre-sale on the grounds of unjust enrichment was annulled. And that's part of that paragraph. That's the focus of the annulment of that paragraph. And then finally, just my last point was on the last argument that Guatemala raised on interest today. They argued that the rate was unreasonable, that a risk-free rate would be reasonable, and that, again, they attacked the reasoning of the resubmission tribunal. That is not properly before you. Again, whether or not they agree with the reasoning of what rate is more proper or not is a debate that we had before the resubmission tribunal, not here. They argued and put on a slide the Ungable decision award and said, look, this tribunal found a risk-free rate. Not only do we not know now, and I do not expect you to be aware of the specific facts of that case, but that's an award from 2012. The parties briefed the interest rate before the resubmission tribunal. If they wanted to rely on that award, that's been available since 2012. That could have been one of the authorities they relied on. Both parties put in different authorities, made their arguments on interest. That's certainly not a ground to be revisited here. So with that, I will end our closing arguments unless the committee has any questions.
Thank you. Do you have any question? Do you? No, neither do I. Mr. Torterola.
I have some administrative issue here that I would like to raise with the Annulment Committee.
Sure.
Today, a new document was introduced, the current draft, the ancestral ICSID current draft. We were shown two articles, one article with two parts, but and of course, claimants had the opportunity to raise it, but this document we didn't have the opportunity to look at before, not even make any argument, because this document was not in the record. So we would like to request 5 minutes, 10 minutes to make an argument on the content of this specific document, because this is just half an article, and like 90% of the document has not been discussed. We didn't have the opportunity because it has been introduced at this late time, and other articles contradict 100% what is being said in Article 4. So I think that we should have the opportunity to address the Annulment Committee on a document that it was not in the record before, and a representation on its content has been done. We should have the opportunity to respond to that.
The third version was in the record. Is that correct? This is just the fourth.
That's correct. And of course, just like they responded to Professor Jones's article that he mentioned in questions, we responded to the draft code of conduct that he raised in questions today. I assume both parties could elaborate or make any comments they want on either of those two, the article and the code of conduct at some point tomorrow.
No, I think it's different because regarding Professor Jones' question, both parties were provided the same amount of time in order to prepare. Indeed, Professor Jones presented the question to both sides, and that's when we responded. This document has been introduced late this afternoon. They had an opportunity to address the document, and we didn't have the opportunity to address the document. So I think that we should have at least 5 minutes to give our thoughts on a document that has not been in the record before.
I raised this question yesterday. Did I not?
And I responded, sir, to you.
I raised it yesterday. I referred to the document. Did I not?
One thing, like don't.
Okay.
Ms. Manica already said it's okay if you comment on the document. So question, is there a pressing need to do it now instead of
I'm
tomorrow?
not asking to do it now. I'm asking to be provided 5 minutes. It can be
Would you
tomorrow.
agree that tomorrow we allot 5 times so you can address this? And I don't know if this varies significantly from the third version, which was already in the record. I don't know if these 2 articles are new.
I'm going to look at that as well.
Okay, because
It's
with
a very
respect
good
to the
point.
other, it was already in the record. So this is just, so you know, it's not an ex novo document. It's just the most up-to-date version of the document that is already and was specifically referred to by a committee member.
I believe in response to
Yes,
Professor
correct.
Jones' question, Mr. Tortorella actually said he was there at the negotiations and talked
Yes,
about.
but the document was not here. I was at the negotiations, but at the negotiations, the document has not been made yet. It's a
5
it's a
minutes
very
tomorrow.
clear difference.
Okay, 5 minutes tomorrow. We hear your views on the document.
Thank you very much. Thank you.
Excellent. Any other points, Mr. Torterola?
No, maybe, I mean, if, I don't know if you're planning to send us questions tonight. I mean, just to organize ourselves for tomorrow. If there is nothing else and we just need to prepare for the question, that's what we are going to do. I mean, I'm not putting any pressure on the annulment committee to ask questions today. I'm just asking what the,
Let's see who sleeps less tonight. It's the committee members are you.
well, personally, we don't need the questions tonight. I was just asking in order to understand what kind of exercise we are going to be confronting tomorrow. Only that.
Ms. Menaka.
I'm in the committee's hands. Of course, we would prefer to receive questions in advance so we can think about them. And the hope is to obviously be helpful and answer as fully as we possibly can, which I think we can do better with advance notice, but you can, I don't know if you have them pre-prepared or not.
We do. We still need to work around them to do something that makes sense and that it's not duplicated, because of course there's some overlapping questions. We want to produce a good document to you. And then we also want you to look at it and decide whether you'd like to answer them orally, or perhaps you'd rather not do so and answer in writing. So, because, I mean, I think it's quite unusual that you get this huge number of questions, and there's some where perhaps you need to elaborate the answer and provide support, and that is difficult to do. And it's really hard for tribunals and annulment committees to, when they really have a need to obtain an answer and to try to understand the answers that parties gave after 2 days of sleep deprivation, where the answer sometimes doesn't make sense and you need to understand what's in the transcript. I think it's in nobody's interest to provide some wishy-washy answer that nobody understands when it's really a point of concern for the committee. So no pressure, because I don't mean to put more burden on you and more work, but if there's real concerns, think about it, whether it wouldn't be more advisable to answer in writing. And perhaps you need to decide it once you see the questions.
I have a point here that I would like to leave it just for the annulment committee's consideration, which is, if the questions are responded here on the spot, and maybe we can elaborate further in writing, at least you will have the opportunity to confront the 2 positions. My concern would be to replace the questions for something in writing that is only going to be once. And we will not have that possibility of that. So in that case, I mean, if the questions are going to be in writing, I would kindly, respectfully, and forcefully request the annulment committee to have 2 rounds. So nothing remains unanswered.
Okay. We hear you.
And my concern, as I've reiterated before, is that these proceedings have gone on for an incredibly long time. We have seen, without getting into detail, there has always been requests for more and more briefing, never enough due process. And I'm concerned that we want to bring this to an end, because one can always continue to reply to another.
Sure.
One advantage, and I fully understand, and it seems like your wish for some written post-hearing briefs is fairly strong. So even though I came into the proceeding, frankly, not wanting to have the written post-hearing briefs, what was motivating that was to put an end, right? If anyone has something to say, we go back and forth and that's it. And then you don't get something in writing. And then the other party saying, well, I need to respond. Well, then they've made a misrepresentation. I'm going to respond, and it never ends. And that's the concern. And it's, very unusual, I think, to have the post-hearing briefs in annulment phase. I don't know of any that has had 2 rounds of submissions. So we've, ventilated a lot of this and written submissions. It's been a long hearing, especially if we have tomorrow. I do think we need to, try to put it to an end. And I would not like to.
I can do the second round in 5 days, 10 days, but the second round needs to exist. We cannot leave something unanswered.
So, gentlemen, gentle ladies, we will do our best to send, even if it's a rough version of our questions, which we reserve the right to include new questions but so you have an idea of what's going on and what's in our minds. And tomorrow in the morning, you tell us there's no way we can address these questions in 3 hours. We need to do that in writing, otherwise it's going to be a mess, and we won't make head or tails of what you're saying because we can't understand, it's all gibberish. So you take a look at them, and tomorrow in the morning, you let us know what you think. Okay? And still tomorrow, both parties tell me more about the cash flows, because I was a bit lost when you addressed that point, and today it wasn't clear to me either on that side. So I really need more input to understand whether historical data were used, were not used, what was, and I need to go through that again to because now we're all exhausted. So perhaps until. And we, of course, and you've got the 5 minutes. So sorry. It's an important point. Thank you. Thank you, Doug. Of course. And we will start with a 5 minutes introduction on the document, and then you will tell us how you feel about the questions. Is that fair?
Yeah, that's fine. Are you envisioning the possibility that we may say we want to answer some but not others at this point, or no? Are you saying we should just decide? Just so unclear.
Yeah, sure. I mean, we welcome any input from the parties. It's always good because we have a debate and both parties can react. But then we also want that to be meaningful and something that we can later use in the decision, not something where we have to work our way through a transcript and nobody understands a thing. Yes?
Okay.
And I must say, I don't know why other committees chose not to have post-hearing briefs. To me, it's the most important brief in a proceeding, always. Perhaps,
I-
well, when there's no witnesses, whatever, but
I think that's in my experience and what I've seen when we did our informal survey
Yeah.
of the decisions. I think it is because it's not an evidentiary hearing. There are no witnesses.
Yeah.